Don't worry about the camera. It's all good. I want to start OJ. It gets so good soon, guys. The Furman, oh my gosh, we are an inch away from the reason, and I didn't even know, but this is the reason why O.J. Simpson trial was so spectacular. Like, it was a spectacle for everyone. And it was 1,000 billion% Furman. He's the only reason. There's no other reasons that this trial was on its head. Yeah, we were saying how the prosecution did this and that. Nope. The arguments the lawyers make soon are fantastic to listen to. I bet you chat is going to go dead silent when they start arguing about these tapes. But for now, we're here. And let's just double check everything. Good. Everything's good. It looks like we only have a few more minutes of this guy. It doesn't look like we're going to see him tomorrow. Or when I say tomorrow, I don't know. I don't know. We could have another stream of him. I can't really tell. I can't 100% tell. No, I didn't see that, but it is a spectacular topic. It's the trial of the century. So lots of people probably did something with OJ at some point, right? But let's get to it. Let's get busy.
I don't know, as I say, I don't know whether it was the gate or the sock. Remember I told you that. So I don't know which one it was. But on one of them I said that.
On one of them you recall saying that, correct?
Yeah.
Then let's assume for a moment, sir, it was the sock. Okay?
Okay, so that's the... so that would be number 2. Right.
All right, then number 2. Let's go to page 2, sir. Because if according to your testimony you found full daughter ion, the full daughter spectrum for the sock stain, it should be revealed in your report, correct?
No.
Sustained. Answer is stand, though.
If your opinion of the results on the graphs generated by Agent Martz's testing was that the full daughter spectrum was revealed in the sock stain, would you not include that in your report?
Not necessarily.
Don't you think that's an important finding, Dr. Reeders?
The fact that I interpreted that as actually showing all 3 ions, I don't know whether it's important. I don't take myself that importantly, but it's a corroborative finding, yeah.
Sir, with respect to the determination as to whether or not a compound is indeed one that you've identified to the exclusion of all others, is it not important, sir, to find as many identifying characteristics and reveal them as you can to substantiate your finding?
Did you say to the exclusion of all others? I never said that, did I?
Did you?
I certainly did not. It's not. Nothing is to the exclusion of all others. That's nonsense. We don't know all others, all the billions of compounds.
So you cannot say then that the substance found in the rear gate and the sock is EDTA from a preserved blood tube to the exclusion of all other compounds?
To the exclusion of all others, I can say it, but I'd be lying.
Then you will not say it, will you, sir?
I'm not going to say that, no.
And looking at your report, sir, if you will, concerning the graphs generated for the analysis of the sock stain.
Yeah. Yeah.
That's paragraph 2, correct?
The what?
Paragraph 2 of your report.
Yes.
In that paragraph, you describe seeing one parent and one daughter ion, correct?
I didn't describe seeing. I described the presence, or I state the presence of a retention time, a parent ion, and a daughter ion.
Okay. You did not put anywhere in this report that you saw the full daughter spectrum as you testified on July 24th.
I have not said anything like that in this report. That's correct.
And you filed no addendum to this report to indicate that, in fact, you had found the full daughter spectrum, not just one daughter ion, correct?
Jude, I had that same problem.
You filed no...
Okay. You know how you click the smiley face to the right of the chat bar to open up all the emojis? You click the smiley face again to close them all.
correction or addendum to your report to reflect the fact that actually you found the full daughter spectrum and not just one daughter ion, correct?
Correct.
And you would agree, would you not, sir, that the more characteristics you can find that line up with a certain compound to identify it, the better it is in terms of confirming your findings. Wouldn't you agree?
Absolutely.
And so the finding of the full daughter spectrum was an important interpretation of the graphs, was it not?
Oral.
It became an important issue, yes.
But it was not one that you included in your July 17th report.
That- Correct.
Now, after you wrote your July 17th report, sir, you were informed that Agent Marks tested his own unpreserved blood and got the same single parent and single daughter ion result that he found in the gate and the sock stain, correct?
Similar, yes.
Not the full daughter spectrum, but the single parent and single daughter. Isn't that correct?
Yeah, he never checked the second daughter.
Sir, did you observe his testimony?
Yes.
It was his testimony that he did not find the second daughter in his own unpreserved blood. Isn't that correct?
He never looked for it.
Sir,
He
did you
said
call...
very clearly he didn't run the 132 because he didn't think it was necessary. That's the third daughter ion. So he never looked for it.
Sir, isn't it true that he testified, not just that he didn't, isn't it true that he testified that his blood, unpreserved blood, gave the same parent and single daughter ion results that were found on the gate and the sock? Wasn't that his testimony, sir?
I think he said similar, yes. Yeah.
And didn't you agree when I cross-examined you last you were here on July 24th that the results on Agent Marks' unpreserved blood were very similar to that of the gate and the sock?
I think I said the results that he obtained and that he had graphs was from the unpreserved blood. Whether it in fact was unpreserved blood, I have no way of knowing.
And when I asked you, sir, whether or not you thought he was lying about that, you said no. You had no reason to doubt that he was being honest in saying he tested his own unpreserved blood. Do you recall that?
I don't recall it, but I'd agree with it. I don't think he's lying. I think he's mistaken in one way or another.
Well, sir, so after you wrote your July 17th report, which you agree shows the single parent and single daughter ion for both the gate and the sock stain, you learned of the result of Agent Marks' own unpreserved blood test. And after that, you came in to testify on July 24th, correct?
Yeah.
And then when you took the witness stand on July 24th, you had filed no addendum changing your findings that were indicated in the report, correct?
Objection, asked and answered. Sustained.
Okay, and those are all
And
the,
when you testified, at that point only, you told this jury that you found the full daughter spectrum on the sock stain. Isn't that correct?
I didn't find it. I saw it full daughter spectrum, yes.
You testified to your opinion that you saw the full daughter spectrum on those graphs on July 24th, correct?
No, wait. I saw the full daughter spectrum. It was presented to me. On it, I pointed out that you could really see all three, even though poorly, but you could see it.
That is your opinion, correct, Dr. Readers?
I pointed it out. Obviously, it's my opinion, but I also left it for anyone else to form their opinion.
And Dr. Readers, between the time that you testified that you testified that your interpretation and your opinion, the full daughter spectrum was found on the sock on July 24th, correct?
I think, was it the sock? I mean, it
Yes.
was one of them. That's all I know, yeah.
But your report does not reveal that you found the full daughter spectrum on the sock, which was written on July 17th, correct?
Asked and answered.
No, I did not.
What testing, if any, did you conduct between July 17th and your testimony on July 24th?
I didn't conduct any testing at any time, as I've repeatedly told you.
And other than, did you review the graphs again between July 17th and July 24th?
Not as much in detail as I had before. I was asked things about some of them. I reviewed that.
Wake up, Josh. Wake up.
Now, isn't it true, sir, that in order to overcome the very similar findings in Agent Marks' unpreserved blood to that of the gate and the sock stain, you decided to change your opinion concerning your interpretation of the graphs on the sock stain so that you could say that it was from preserved blood. Isn't that correct?
No, that's absolutely misleading and incorrect.
Well, sir, let me ask you this. Is there a difference in science between the term detected and identified?
Sure there is.
When you detect something, that means that it may be consistent with a compound, but isn't necessarily that particular compound that you're trying to look for.
Not necessarily. Detection can be so strong that it is at the same time a positive identification. Ordinarily, in the forensic toxicologic sequence of analysis, where what we call in forensic toxicology an forensically acceptable quantum of proof, you do two physicochemically independent tests. The first one, preferably, is one that is particularly sensitive, even at the sacrifice of specificity, and you call that a detection test. And then you do a second independent one, which is a corroboration or negation test. And so between the two, you have an identification. As a basic requirement.
Then to boil it down, sir, if you have detection, you may or may not have the compound. If you have identification, you in fact have the compound.
No, you may or may not. You can't ever be sure. You go to the point of reasonable scientific certainty with the tools that you have and what you have available.
Then would you agree that there is a distinction, sir, between something that is presumptive for a certain compound and something that is identified as a certain compound? Is there a higher degree of certainty with respect to a compound that is identified than a compound that is determined to be presumptive for?
Presumptive can be as strong as identified. Any analysis that you do for a compound, if you get a result that fails to disprove its presence, is presumptively positive. If you have several different types of tests, all of them fail to rule it out by showing could be there, then together between them we call this reasonable certainty of identification. That's how we work that. That's the mental algorithm that's standard in this community. It means you don't prove anything, you fail to disprove. That's what you do.
Then you do not agree that there's a distinction between the terms detected and identified? Is that your testimony?
There's an obvious difference. They are two different words, and they require, in any particular case, definition.
Then, Dr. Reeders, would you agree that identify implies a higher degree of scientific certainty than detected?
A high degree of scientific certainty for identification, yes, but not for presence or absence.
Yes, doctor. And presence or absence means it may or may not be there, correct? It may
Well,
be there, but it may not. And when you say identified, it is a higher degree of scientific certainty. Isn't that true?
It still may be the compound, or it may be something else. It can always be difference. You have failed to disprove its presence. Every time you fail to disprove, you add another quantum to having identified it. You fail to disprove. You run a series of tests. If these tests are all positive, you have failed to rule out that compound. At one point or another, you say, I've done enough tests, I'm reasonably sure that's what it is, taking everything else into consideration.
All right, doctor, would you say, let me ask you a different question. There are such things as presumptive tests, correct?
Any single test is no more than a presumptive test.
Well, then, do you see any distinction between a test that is a presumptive test and a test that is a confirmatory test?
Yeah, confirmatory is done after the presumptive.
All right. So when something is done on a presumptive test and comes up positive, you say, we have a result that is presumptive for X, whatever it is you're looking for, correct? And then when you go on and do further testing, you will confirm the presence or rule it out, correct?
Confirm it or negate it with the next test. If you do a third test, you do again the same process. It confirms the previous one or it negates the previous results.
And wouldn't you agree, doctor, that in mass spectrometry, you can only confirm a compound if you have the full daughter spectrum?
Absolutely not. It's nonsense. Whoever gave you that idea?
If people who were expert in the use of the tandem mass spectrometer said that that's what you had to do, would you disagree with them?
No, that's what they have to do. That's their opinion, but it isn't. As I said before, it's not etched in concrete. It's not from Olympus.
All right, so it's
A lot of identifications in forensic science in MSMS are done on the basis of the parent ion and a single daughter ion. It's done every day with people who have that instrumentation.
Then your opinion is, Dr. Reeders, that you're entitled to create your own standard for when something should be identified or not. Is that your
No.
testimony? Is it your testimony, sir, that you feel that you can make an identification based on your own criteria?
If they are only my own criteria, then they are junk science. If they are criteria which are shared by my colleagues, then I can say yes. You know, if they've stood the test of time and of cases.
But then it's your opinion, doctor, that you set your own standards and you determine whether or not a certain standard is correct or not.
You know, I don't set the standard.
If others disagree with the standards you have set, do you change your opinion?
Just because they have a different opinion. No, one debates it, and when comes a point where there's proof that one is right, the other is wrong, then you change your mind.
But you decide when that happens, isn't that correct?
Either I or the scientific community decides. Up until the point that there's a consensus, if people have my opinion, share my opinion, then we are a group that have one opinion. Somebody else has another opinion. Doesn't mean that either one is right. Eventually, it turns out that one or the other one is right, or perhaps both are.
With whom did you consult to determine that your standard of a single parent and single daughter ion is sufficient to say that you have identified of the presence of a certain compound in a mass spectrometer?
I looked in the literature, number one, on MS work. I have over the years many times because we've been considering getting into it.
What literature is that, doctor?
Huh?
What literature?
Scientific literature, technical literature from the ones that I looked at were from Finnegan, who makes the TSQ instrument that I think Dr. March used. Then Hewlett-Packard, who has put out that kind of an instrument, MS instrument.
And do those articles indicate that it's appropriate to identify the presence of a compound as opposed to just detect it on the presence of a single parent and single daughter ion? Is that what they say?
In some cases, yes, it is.
Could you produce those articles for us, sir?
No, I suppose I could if I went back and called them up to send me copies of them.
Could you please use the microphone, Dr. Readers? The court reporter's having a
Sorry.
hard time. And if others in the scientific community disagreed and felt that that the standard you have enunciated for us of a single parent and single daughter ion for the purpose of identifying a compound was inappropriate and too lax, you would simply disagree with them. Is that your testimony?
Yes, I would. I mean, they're entitled to their opinion, but it's not mine. We have no proof of that.
All right. Now, you indicated that there's a difference between presumptive and confirmed, correct?
It's a semantic difference, yes, but it's an important difference, but it is semantic. It refers to the first test, which no matter what it is, it's the first test. The second physical-chemically independent test
Now
that
we're all
corroborates
safe.
or negates. So
Bobby
it
got his
becomes a
coffee.
confirming or negating test.
Let me show you the last page of your report. Now, directing your attention, sir, to the last paragraph, which is labeled B, where you indicate, thus, the finding of EDTA in a microblood specimen, such as in the present ones, is consistent with, indicative of, and presumptive for the blood having originated from a specimen which has been placed into a usually lavender top blood collection tube, such as is commonly used to draw blood from a living person and keep it from coagulating. And the terminology you use in that paragraph, sir, is consistent with, indicative of, and presumptive for. Isn't that correct?
That's correct.
And in none of those words do you indicate the final or confirmatory language such as identify. Isn't that right?
Well, in this case, it's not a question of identified. When you talk about the, well, yeah, I guess so. It doesn't say identified that was it. You know, that was EDTA blood from a tube, because you can't say that. You can only say this is EDTA blood. Presumably, because the most common source for it is a lavender top tube, it came from a lavender top tube. But it doesn't mean it did, in fact, come from that. It could come from other sources. I don't know where it came from, in short.
And the other sources it may come from, sir, well, let me ask you this. Are you aware that there are 4 different types of EDTA?
There are many more than 4, if you don't mind.
But at least 4, isn't that right?
There are more than 4. So there are 4, but there are also much more than 4.
And one is calcium disodium, isn't that right?
That's one of them, yeah.
And that's used for a food preservative, correct?
Calcium disodium EDTA is used for a lot of things, including treating lead poisoning.
Right. As well as a food preservative, isn't that right?
It's not a preservative. What it does, it ties up metals and keeps the color and flavor of food intact. It doesn't keep it from rotting.
Are you aware that it's also used as a food preservative? Did you know that?
It doesn't work as a preservative. Preservative means prevents bacterial degeneration. It doesn't do that. It's not an antibacterial compound.
If I were to show you, sir, an article, excuse me, a page out of the Merck Index, indicating that calcium disodium was in fact used as a food preservative along with the purpose of treating lead poisoning, would you change your opinion, sir?
Of course not. It's a preservative of color and flavor, but not of food as edible food. A food preservative is something which keeps food edible, and this won't do it. It'll be bacterially degraded, just as if you didn't have it in there.
All right, then it's your testimony that although it may not preserve food, it's a color retentive product
In
for the
some
food?
cases, look what it does. It ties up the metals that oxidize color and flavor. It inactivates them. That's its purpose in food.
All right, then it is used in food, though, is it not?
Yes, it is, sure.
All right. And then there's disodium only, correct?
Huh?
Disodium, I'm talking about the types of EDTA. There is also disodium, straight disodium.
Disodium EDTA is another one. That's disodium dihydrogen EDTA, which when you put it into food, it usually very quickly goes to either calcium or, depending on what, mostly calcium.
All right. And then there's sodium EDTA, correct?
Yep,
And there's trisodium EDTA.
yep. There are many others, as I said.
Now, the way the anticoagulant works is that it binds up the calcium in your blood, which is a clotting agent. Is that right?
That's the anticoagulant effect, yes.
Now, do you know which form? We've just gone through 4 of the forms of EDTA. Do you know which of those can be used as a food preservative, sir?
You can use any one of them because the purpose of it is to tie up iron, copper, and a few other heavy metals which cause changes in color and changes in flavor. So you can use any one of them from a technical point of view, provided the acidity or basicity of the food is properly adjusted. The trouble is that the free EDTA isn't very water soluble. The sodium EDTA is.
Now, do you know whether these forms of EDTA were ever tested for the purpose of determining what the maximum tolerance would be in a normal, healthy person?
You mean in food, is that it? When you say maximum tolerance, how? Intravenous or in food or what?
No,
Vast
sir. I asked you
difference.
whether there was any testing that you know of that determined whether any of the forms of EDTA that we have just talked about, those 4,
Right.
was ever done to see what the normal level would be in an average healthy person.
Yes, the study of Foreman and Trujillo dealt with normal healthy persons,
Your Honor,
and in
objection,
it they
non-responsive.
determined
Overruled.
Non-responsive.
Overruled.
and in this they determined what the level in their blood was.
Absolutely, you should be on
which was
Tinder.
in the low part
And
of the below their
OnlyFans.
detection limit.
Bobby.
Ladies and gentlemen, we need to take a comfort break for the jurors. We'll take 10 minutes.
Josh had actually asked me if I could try to talk you into OnlyFans. So, this is me trying. But you really should. It's me. I have to get to work here. Sometimes it catches me off guard that I have work to do. Ooh, we're fast forwarding. That means we're getting closer to Furman every time we fast forward.
All right, thank you, counsel. Proceed.
All right, Dr. Reeder, when I questioned you when you were last here on July 24th, I asked you whether testing had been done to determine what the average level of EDTA might be in the average healthy person, and you agreed there had not been such a test. Do you recall that testimony, sir?
I recall the testimony that there had not been a population study, as one generally as ATSDR and other agencies do, that I know of.
That would determine what the average level, if there is one, of EDTA in the average healthy person, correct?
Except for the small Foreman and Trujillo sample.
I am sir,
That's a sample.
I've asked you, that test was not conducted to determine what the average level might be in a healthy person of EDTA. Isn't that correct, sir?
I don't know what it was conducted to, but it gave you that information and a small number of people.
Sir, do you recall testifying on cross-examination back on July 24th that was not the purpose of that testing back in the 1950s?
I'm sure that wasn't the purpose of the testing to determine the world population, but it was to measure the normal in those people, among other things.
Sir, do you recall testifying that with respect to that paper, they were attempting to inject EDTA for the purpose of going into studies about how it would chelate with lead poisoning and tracing it through the body? Isn't that correct?
No, that particular paper is to study the pharmacokinetics of what the body does to EDTA. That's what the purpose of that paper was. And that includes determining that it is not detectable when you don't give it, or that after you give it, after a period of time, it disappears. It doesn't stay in the body. That's what the Foreman and Trujillo paper was, and they repeated that with some additions in a book that came out a couple of years later from a symposium.
As a matter of fact, sir, isn't it true, actually, that study found that it would pass through the body with the exception of about 5%, correct?
No, oh, no. Either you don't understand it or you're saying the wrong thing.
But
It
objection,
showed-
Your Honor.
it showed
After
that-
no is non-responsive.
Yes. Next question.
Dr. Reeders, isn't it true that that study made no effort to determine whether average healthy people had a certain trace amount of EDTA in their blood at any given time? Isn't that true, sir?
No, I don't think so.
You think that that was the purpose of that study?
One
Is
of
that
the
your
purpo-
testimony?
One of the purposes that the baseline was something or zero. That's what it's part of it, yes. In those people,
They took a few people and they injected them with EDTA, isn't that correct?
among other things, that's what they did.
What test do you know of, sir, that took average people who had not been injected with anything to determine whether some form of EDTA was present in their blood? What test can you tell us about?
That particular one, because it took zero time, that's when they hadn't been injected.
Objection, Your Honor, non-responsive.
Overruled.
What test do you know of, sir, that went out and took people off the street, took their blood, and looked to see whether there was EDTA in it? What test did that?
Told you before, I don't know of any.
Thank you, sir. Now, in this case,
Overruled.
if a scientist is trying to prove that a substance is a particular compound, it's incumbent upon that scientist to do any test available to establish that, correct?
Would you repeat that question, please?
If, as a scientist, you are trying to prove the presence of a particular compound, wouldn't you agree, sir, that it would be incumbent upon you to do whatever tests are available and appropriate to do that?
Or else take someone else's data and review them.
All right, but then in that case, that person would have done the testing, correct?
Beg pardon?
In that case, someone else would have done the testing, correct?
Yes.
But the testing would have been done. You agree?
If it's available, yes.
And
I'd review the testing method and the result.
And testing is the cornerstone of science, isn't it, sir?
No, the cornerstone of science is the application of the scientific method to the investigation of phenomena.
And the application of the scientific method, sir, requires that testing be done to test hypotheses and determine whether you can determine a theory is correct or incorrect. Isn't that true?
That's one of the cornerstones. The other cornerstone is to formulate hypotheses.
Okay. And once you formulate the hypotheses, you have to determine through testing whether the hypothesis is correct or incorrect.
Or you let somebody else do that.
One way or another, the hypothesis is tested. Agreed?
Again and again, yes. That's what research means.
And hypotheses may prove to be correct and they may prove to be incorrect. Wouldn't you agree, Doctor?
Hi, KB.
Well-
No problem.
With a genuine scientific approach, you never say that a hypothesis is correct, but you say that all tests to knock it over have failed, so it still stands until the next person comes along with a better test and perhaps knocks it over. That's why it's a hypothesis. But for the present, it has been, everybody has failed to disprove it, let's put it that way.
And theories are disproven, though, are they not?
What is?
It does occur that hypotheses are disproven by testing. Isn't that correct?
That happens all the time.
All the time. I'm sorry, is that what you said?
That's the purpose of science, is to set up hypotheses and then make tests to knock them down. And more commonly, that's successful rather than the failure to knock it down.
Now, you've been working on this case with the defense since September, October of 1994.
I have been working on these cases. I've answered various questions, and then I started working on these papers after I got them, sure. I think September is when they first asked me some questions and asked me to look at some things.
So were you retained by the defense in September of 1994?
September or October, I think.
And since that time, how many hours have you spent on the case total?
I have no idea. I only write it down and send it in, and then that gets billed. But I don't personally keep count of it. A lot of time, I can tell you that.
You don't personally keep count of your hours?
I don't keep them with me.
You don't keep
I
them?
told you I send in the sheet with the hours, and that's it. I don't keep adding up on my fingers how many have I worked on.
Do you send the sheet to the defense? Is that it for
No,
billing?
I send the sheet to our billing department. They take care of those things.
And if you could, over the lunch hour, sir, I would ask, could you have your lab fax you the billing sheet that you've submitted in this case? Could you do that, sir?
I can call up and ask them to send you a copy of the billing, yeah. Although I think probably they have it right here.
Okay, well, we'll determine that, sir. Could you
Beg your
also
pardon?
ask we'll determine that. I'll
All right.
speak with them. Could you also, sir, ask that your lab fax you those articles, the manufacturer's articles that you refer to, Hewlett-Packard and Finnegan, in which you state that they say it's appropriate to identify a compound based on the detection of a single parent and single daughter ion?
I don't know what to ask them. I'd have to look and ask Hewlett-Packard whether they have a copy.
Is the observation or detection of a single parent and single daughter ion. Are there such articles, sir?
I believe yes. I think there are, and I think I could locate them.
And if you would, please try to locate them over the lunch hour.
No, I can't do it over the lunch hour because I'd have to go back and do a literature search.
Then you will forward it to us when you get back to your lab.
If I find it, I will. If not, I'll send you a note that I haven't found it. Is that satisfactory?
That's fine. Thank you, sir. Now, would you say that the number of hours total that you've spent on this case was over 100?
including the time I've spent here, I would say probably.
What experiments have you conducted since September or October when you
He's
were
done
retained in
100
this case in
hours today
1994
alone.
to prove that EDTA will degrade in sunlight?
Asked and answered. We asked that question on the 24th.
What experiments have you conducted since September of 1994 to prove that EDTA will degrade if it is left on metal?
Objection. Asked and answered. Sustained.
What experiments have you conducted to determine whether EDTA will degrade when it is on paint?
Yeah, objection. Asked and answered. And counsel arguing. Sustained. Why don't you just ask him the omnibus question? Did you conduct any experiments regarding degradation?
Did you conduct any experiments, sir, with respect to the degradation of EDTA when exposed to any kind of compound or element?
No, I looked at the literature, but I haven't done any experiments myself.
And is there any literature that you're aware of that determines that is based on experiments to show that EDTA will degrade in the presence of paint or metal or fertilizer or rust?
There's lots in the literature about the breakdown of EDTA.
Objection, non-responsive.
And as far as, in sludge, which contains all those things, yes.
Dr. Readers, is it your testimony that there are articles based on experiments that show that EDTA degrades when exposed to paint or metal or fertilizer or rust?
Specifically to those substances only, I'm not aware of any.
Would this be a
Now,
good
it's
spot?
some... Yes, that's fine.
Excuse me, except for Dr. March's experiment.
All right, ladies and gentlemen, we're going to take our recess for the noon hour. Dr. Readers, you can step down. Please remember all of my admonitions to you. Don't discuss the case amongst yourselves. Don't form any opinions about the case. Don't conduct any deliberations until the matter has been submitted to you. Don't allow anybody to communicate with you with regard to the case. We'll stand in recess until 1:30. All right. All right, back on the record in the Simpson matter. All parties are again present. We have a few evidentiary matters to take up before we invite the jurors to rejoin us to conclude with Dr. Readers. All right, Mr. Ullman, do you want to be heard on behalf of the proponents?
Yes, sir.
Good afternoon, sir.
Your Honor's ruling last week with respect to the access to the report of the Internal Affairs investigation and the reporter shield law were very careful, narrow rulings addressing essentially the admissibility of false leaks, as Your Honor characterized the information in terms of fabrication or disinformation, primarily with respect to the defense contention that blood was planted on the sock. And the court concluded that it was speculative to infer, even if a source of the disinformation were the LAPD, that the source participated in the planting of evidence or spoke directly with someone who did. We accept that ruling, even though we disagree with it. My purpose today is not to seek a reconsideration of that ruling. But the issue that we'd like to address today is a broader one, and that is whether the leaking of accurate information by the Los Angeles Police Department is material and relevant to the defense. And in addressing this broader issue, we would ask the court to take a broad view of the defense theory of this case in the terms in which that theory will actually be argued to the jury. This aspect of the defense in this case has frequently been mischaracterized by the prosecution, and I think that's part of the problem. In questioning witnesses, they've asked witnesses whether they are part of an elaborate conspiracy to frame Mr. Simpson. And that kind of sarcasm completely misses the real thrust of the defense in this case. We don't have to show an elaborate conspiracy to frame an innocent man. In fact, an elaborate conspiracy would be inconsistent with the pervasive ineptitude that has characterized both the investigation and the prosecution of this case. Our defense, quite simply, is not that there is an elaborate conspiracy, but simply that the evidence in this case cannot be trusted. It cannot be credited. It lacks integrity. That's the defense. And no one should be convicted of a horrendous crime and be deprived of his liberty on the basis of evidence that cannot be trusted. Now, we've offered a number of reasons why the evidence can't be trusted. First, some of the persons who collected or handled the evidence are corrupt. there are individuals involved in this case who are capable of planting or manufacturing evidence, and who did so in this case. Secondly, some of the persons who collected or handled the evidence in this case are incompetent. Acceptable professional standards for the handling of evidence were not met or maintained, and the documentation that accompanied the collection of the evidence lacks credibility, lacks precision. Thirdly, some of the persons who collected or handled evidence in this case are careless, that the sophisticated scientific testing is of little use if evidence has been contaminated by careless handling. And finally, some of the persons who collected or handled evidence in this case are manipulative. The goal of this investigation was not a search for the truth, but a search for the restoration of a tarnished image. Evidence and information were handled in ways not designed to assist the court, but in ways designed to enhance the public image of the Los Angeles Police Department. I think it's often overlooked that the motive to plant blood on a sock or on a gate may not have been to frame an innocent man. It may have been done by persons who were convinced that Mr. Simpson is guilty and who were concerned that previous screw-ups had compromised the ability to prove that guilt in a court of law and would have to be enhanced by extracurricular efforts. Now, the motive doesn't make any difference. We don't have to prove the motive. The integrity of the evidence is just as questionable whether it was done to frame an innocent man or whether it was done to restore the tarnished image of the Los Angeles Police Department. And in addressing the materiality and the relevance of the leaks, we believe the appropriate question for the court to ask is, does evidence of leaks, even of accurate information, by the Los Angeles Police Department assist the trier of fact in answering the question, should I trust evidence that was collected and processed by the Los Angeles Police Department? Knowing, for example, that reports of scientific test results faxed to the Los Angeles Police Department were given to newspaper reporters before they were given to prosecutors or to defense lawyers or to the court in this case. Does that tell you anything about the competence and care of those who were entrusted with maintaining the integrity of this evidence? Now, while Your Honor has suggested that the leak of September 21st was a fabrication, we would ask you to just put to one side the false part that DNA tests had already been conducted on those socks. The reports were accurate in leaking the information that blood had been uncovered on one of the socks or discovered on one of the socks, and that this blood had been linked to the victim, Nicole Brown Simpson, by means of testing, even though the part about what kind of testing was conducted was inaccurate. And if you look at the timing of the leak of that information, the part of it that is accurate, it comes the day after the LAPD laboratory conducted a test to show the PGM subtype of the blood on that sock, and the knowledge even that that test had been conducted had not been transmitted to the defense, to the prosecution, to the court, and the leak came on the same day that this court made a finding of recklessness on the part of the chief investigating detective in the course of pretrial motions in this case. That finding, the court will remember, was made on September 21st, 1994. And it doesn't take a rocket scientist to conclude that what was going on may have been news management, controlling the spin. And aren't we entitled to ask, do you trust evidence collected by the Los Angeles Police Department in this case, knowing that the security and confidentiality of evidence was manipulated in order to shape public opinion? Now, we can put to one side whether its purpose was to manipulate public opinion against O.J. Simpson, knowing that a jury was in the process of being selected. Assume that wasn't even the purpose, that it was to manipulate public opinion in favor of the Los Angeles Police Department on a bad news day when the LAPD was taking a hit. The result is the same, and the result is we have less trust in the LAPD. We have less confidence in the evidence that they collected and handled. And finally, I would ask the court to consider the materiality and relevance of this evidence as rebuttal to contradict the testimony of key prosecution witnesses. The testimony, for example, of Detectives Van Adder and Lang, that the investigation conducted in this case was a thorough and professional one consistent with their years of long experience as homicide detectives. The implicit message of that testimony was simply, you can trust us, and you can trust the evidence we collected. And the lapses in procedure, such as bringing a blood vial of the suspect back to the scene in a coat pocket, were minor and inconsequential and don't affect the integrity of the evidence.
Actually, I thought it was in a gray envelope.
A
Gray envelope.
Well, you're right. It was in a gray envelope. Bringing it back to the crime scene, however, certainly was a departure from normal procedure. And there have been lots of departures from normal procedure that have been brought out in this case. And those departures raise questions. And the counter to those questions has been, you can trust us. You can rest assured that the evidence was handled with integrity. And that's the relevance of these leaks. Because it suggests to the court, to the jury, as the finder of fact, that you need to really wonder about how much confidence you can have in this evidence, how much trust you can have in those who collected and processed it. There's also the testimony of Mr. Matheson with respect to elaborate special security established for the security of the evidence in this case. I mean, they really describe the evidence control facility as a Fort Knox. And if penetration of that level of security was possible to manipulate information by selective leaks of that information to the press, that raises an inference. And that inference is a question. Can you really trust that the evidence was as secure and as safe from any tampering, from any contamination, from any compromising, as the prosecution would have us believe? Now, of course, there's lots of other evidence to support the defense case, to show that there was corruption, there was incompetence, there was carelessness, there was manipulation. But the test of materiality and of relevance is not whether the evidence is needed to prove a fact that can't be proven by any other means. It's whether the evidence supports an inference which is of consequence to this case. And I can't think of any greater consequence to this case than the integrity of the evidence, the degree of trust we have in those who collected and handled it, the degree of confidence we have in their credibility. Now, Your Honor mentioned in your order that leaking is nothing new, that from the Pentagon Papers to Watergate, we have seen leaks used to manipulate the press and to put a spin on information. And one reason may simply be that those who are entrusted with sensitive information don't deserve to be trusted. And one consequence of a breach of that trust should be, when it is exposed, they have to answer for it. And one place you answer for it is in a court of law, in which you are coming in and seeking to persuade a finder of fact, you can trust us. You can have confidence in the way we handle this evidence. And that is precisely why we believe it is relevant to show that these leaks came from the Los Angeles Police Department, leaks of accurate information, to undermine the trust that the jury should have in the integrity of the evidence.
Mr. Allman, what are the specifics of your offer at this point? What do you intend to present?
We would like to present simply a confirmation of the accuracy of the published reports with respect to accurate information. That is, that the leaks of the faxed information from Cellmark that came to the LAPD on September 12th actually appeared, published in newspapers before they were delivered to the defense or the prosecution in this case. We believe we can separate the truthful part of the report of September 21st from the untruthful part. We would not offer the portion relating to DNA testing, but we would offer the portion relating to finding blood on the socks, to an attempt to link that blood to Nicole Brown Simpson, and showing that this information was published, appeared on television before that information had been conveyed to this court. And we would also offer Mr. Bosco's report with respect to the active attempt to shop information around to news media, regardless of us showing that that information was false or inaccurate.
Thank you. Mr. Goldberg?
Good afternoon, Your Honor.
Good afternoon, Mr. Goldberg.
Kind of reminded here of one of those monster movies that we've all seen where the monster is impaled and burned and stabbed, and just when you think it's finally going to rest, it rises up again out of the ashes.
You're probably speaking of Friday the 13th.
Yeah, I think so. I'm referring here, of course, to the matter now before the court, not Professor Ullman. Your Honor, when we spoke very briefly about this issue on Thursday, it was mostly in the context of scheduling. I made a comment to the court to the effect that I felt this was a simple issue. And I just wanted to say to the court that I fully appreciate the complexities of this litigation that have confronted this court. And I did not mean in any way for that comment to in any way underestimate or be contrary to my appreciation of the extraordinary task this court has to face, perhaps one that no other judge has had to face before in any litigation in terms of the number and complexity of the legal issues, the number of lawyers on both sides.
Well, wait till you see asbestos litigation.
Well, and the shortened pretrial and the extensive media coverage, and I simply wanted to make it clear to Your Honor that that comment in no way was meant to in any way derogate my appreciation of those complexities. What I did mean by that, Your Honor, and perhaps it was a little bit misstated, is that in our view, this isn't a simple issue, but it is a non-issue, or an issue that has already been resolved. In other words, that Your Honor has already made all the rulings and all the decisions that are necessary in order to determine the admissibility of this evidence. And that is that Your Honor has already made a determination in the context of discovery issues that the evidence here is not material. And in going back to the record of the arguments that I believe took place on Wednesday, the court started out by deciding the question of whether or not this evidence was going to be sufficient, or the prima facie showing was sufficient for the purposes of discovery of police personnel records. However, the court's written ruling only addressed the issue of the Shield Law, but the court actually disposed of both discovery issues, one orally and the other in writing. And during the oral pronouncement of ruling, the court said that this record does not support a finding that access to the results means access to the evidence itself. That assumes that access to the results does not exist in this case, and the mere fact that the results as reported were incorrect is a clear indication to the court that the source of this leak did not have access to that information and was not a source close to the investigation and was not, in fact, knowledgeable. The court then went on to state that under the Delaney test as well, the court was making a finding that the entire record does not support a finding of materiality. So the court did not rule, as counsel I think has suggested, that this evidence wasn't relevant on the issue of suggesting that evidence on the socks was planted. The court ruled that it was not material, period, under a variety of theories that were proposed by the defense. Now, in trying to count what was just said here this afternoon by counsel, it looked like he said approximately 3 things, or offered 3 alleged areas of relevancy of this evidence. He said something that I think is essentially the same as his rush to judgment argument, that the fact-finding process was not an objective search for the truth. I've already extensively argued that. Counsel has on a number of occasions, and the court rejected that as being a basis for materiality. The second thing that he said was that it shows that the handling of information was not trustworthy, and therefore it undermines the confidence that the jury should have in the maintenance of the security of the evidence. And the court heard and rejected that argument as well. There is no logical connection between the two. And then the third argument that I heard counsel make today, which I also believe was made when we last argued this, was the argument that this was an effort to shape public opinion on behalf of the Los Angeles Police Department. And as the court can recall, my response at the time that it was first made was that if some police officer somewhere out giving traffic tickets was proselytizing that in his opinion the defendant was guilty and the evidence overwhelming, that clearly there could be no possible relevance to that case. So this issue again was argued and rejected by the court. The court has very simply found that this isn't material. Now, we suggest that that disposes conclusively of the evidence in this case, because as I believe the court's comments indicated when we argued this issue last, the issue of materiality for relevancy purposes is only different from the issue of materiality for discovery purposes, insofar as for discovery it would be a slightly lesser standard, because the issue there is whether or not a prima facie showing can be made that they're going to discover evidence which might be beneficial to the defendant. They don't even have to show that it's necessarily going to be admissible per se. So here the standard is higher in terms of materiality than it was at the time the court was ruling in the context of a discovery hearing. So we would suggest, and we are very confident in this, and I think the court's comments are consistent with this, that it is not logically possible for the court to rule that this evidence, which was so immaterial that the court wasn't even going to allow further discovery on the issue or further exploration to perhaps give the defense the opportunity to shore things up a little bit. It was so immaterial for those purposes, is nevertheless sufficiently material that not only should it be admitted, or not only can it legally be admitted in front of a jury and overcome a relevancy objection, but it could also overcome an Evidence Code Section 352 objection that it is more probative than prejudicial. Those two positions are irreconcilable. The court cannot logically come to the conclusion that it's so irrelevant that no further discovery should be allowed, and then at the same time conclude that it's sufficiently material and probative under 352 to come before the jury.
But didn't we hear a different offer today? The offer being that actual accurate, yet arguably premature disclosure of information is somehow relevant. That's a
Yeah,
different
but-
argument than we heard before.
Yeah, somehow relevant, but relevant to what? He said it's relevant to rush to judgment, relevant to mishandling of information, and relevant to an effort to shape public opinion, and all those arguments have been previously made. So what I'd suggest to the court is this. I think we all recognize that to the extent that the defense was unable to show that this was an individual close to the investigation, that all of the arguments of relevancy were extremely tenuous. And we gave the elevator example of someone overhearing in the elevator, and counsel was never able to come up with a satisfactory explanation of how on earth that could be relevant. But they also couldn't show how it could be relevant even if a source much closer to the investigation had heard it. So if the court was not going to give them the opportunity for discovery purposes, at least to try to pinpoint how close this individual was to the investigation, then how can we say in the absence of knowing that information at all, and in a record that leaves us to believe that the elevator operator possibility is equally reasonable as the investigating officer possibility, how in the state of this record, where either of those inferences is equally reasonable, can we say that this is relevant for the purposes of admissibility? I don't think we can. And it's of great concern to the people, Your Honor, not only, of course, that the court make the correct rulings, and we believe that Your Honor has, especially in this regard. You gave it an enormous amount of attention and heard an enormous amount of argument. And we recognize that this is an issue that is largely an issue, mixed issue of law and fact, and therefore subject to the trial court's discretion. It's not only important to us that you make the right rulings, but it is also in the people's interest that the record is consistent, so that if we get to the point, as we believe we will, where a reviewing court is looking at what the court did, they will be able to understand that Your Honor exercised your discretion, understanding completely what the legal standards were, and correctly understanding the law that applied. And we believe that saying that this is admissible evidence, already having ruled that it's immaterial for discovery purposes, is so illogical and so inconsistent that we would be concerned about the inconsistency of those two rulings for purposes of the record. And if the court, for some reason, is now going to reevaluate all of these issues, and we certainly don't think the court should do that, that the court would also have to reevaluate these issues for the purposes of discovery as well in order to be logically consistent. And that would be the only way of doing it. And then Your Honor would have to, in effect, say, well, if this is the kind of thing that can go before the jury, maybe we should give the defense the opportunity to shore it up a little better. Now, we've argued over and over again as to why it's irrelevant, why it's immaterial. And I hate to repeat those arguments again here, Your Honor. I just don't think that we should. I think that Your Honor has ruled. I think the court should simply decide that your previous rulings are dispositive of the issue now before Your Honor. Maybe there's some additional question I can answer. Maybe Your Honor feels that they've somehow materially phrased the issue differently, and I haven't adequately addressed that. If that's the case, I'd like the opportunity to do so.
Well, as I posed to you, the offer that was given just now by Mr. Ullman included the true reporting, however, arguably in a premature manner.
Of what? Of the SOX?
Of events, any event.
But
Focusing, for example, on the PCR testing that was conducted by Cellmark and reported to the Los Angeles Police Department. My recollection is somewhere around September the 8th, yet those results were not transmitted to the district attorney's office until approximately the 14th is my recollection of the record. However, the news reports appeared in the Los Angeles Times regarding that testing on September 11th. Is my recollection of the record. The dates may be a day off or two.
now, previously the defense only wanted to introduce reporting as to the SOX. Maybe now they're broadening it and they also want to introduce other reporting. I don't know.
That's what I heard Dean Ullman to say.
Okay. And then we have to ask ourselves, what is it relevant to? I mean, just saying, well, it's relevant, we'd like to get it in, doesn't do it. What is it relevant to? I think that they're now conceding that Your Honor has decided that none of these leaks, so-called leaks, are relevant to the issue of the SOX and planting evidence on the SOX. It doesn't go to evidence planting. Does it go to bias? Well, we'd have to know who on earth was responsible for the leak before we could even get to the issue of bias. So it doesn't go to that. We've heard rush to judgment, and we've argued previously that this whole question of rush to judgment is not an issue because the subjective mental processes of the investigating officers or the prosecutors is not relevant. If it were, as I previously stated, we'd need expert testimony as to what a reasonable police officer would have believed in terms of the defendant's guilt and when he would have formed those beliefs, and then they'd be entitled to call an expert in rebuttal to suggest to the contrary. It would just take us down a path that would lead us into a form of inquiry and a type of inquiry that's totally irrelevant here. The jury has to decide this based upon the objective persuasiveness of the facts, not whether they think that the detectives correctly evaluated those facts. Is it relevant to show some sort of an effort to shape public opinion? Well, if it is, then does the prosecution get to put in the numerous press conferences, I guess you couldn't call them leaks, by the defense in their efforts to shape public opinion? You know, there are many people watching this trial that do believe that there is a conspiracy of sorts who would characterize that conspiracy to obstruct justice in their minds as emanating from the defense's efforts to try to saturate public opinion with their particular viewpoint and their particular spin on this case. I don't think that's admissible. I mean, whether it's proper or not, whether it should be done or not, it is not admissible. So are we going to be able to get in that evidence? I do not see any logical theory as to how on earth you can try a case based upon information that has been given to both sides by the press, especially when they can't even pinpoint, and there's no way of being able to pinpoint who on earth was responsible, if anyone for sure, of giving this information to the press. Now, with respect to the admissibility of this evidence, Your Honor, there are some other issues that I'd like to get to, but I don't think I need to unless the court somehow decides that it's going to reevaluate the very carefully worded written decision, an oral decision that Your Honor already made. But those other issues include things like hearsay, absence of foundation, the fact that a lot of this evidence would require witnesses to offer inadmissible opinions as to who it was that they were speaking to without foundation, as to how they know who they were speaking to. There are a lot of other legal issues dealing with authentication, dealing with hearsay, dealing with opinion and conjecture. But I would prefer, with the court's permission, not to address those at this point. And there's also another issue beyond those as to how we are going to cross-examine witnesses who would only give us partial information and invoke some kind of a shield in order to prevent any kind of meaningful cross-examination. I would simply offer conclusions and opinions without allowing us to try to figure out what the basis for that conclusion and opinion is. With Your Honor's permission, I would ask to be allowed not to argue those right now, and I previously argued them in other contexts before anyway, because they are not relevant if the court concludes that its rulings are already dispositive on this issue.
Thank you.
Thanks.
Mr. Ullman?
Your Honor, with respect to the dates of the Cellmark leak, I believe it was a report from Cellmark dated September 8th that was faxed to the Los Angeles Police Department on September 12th, and then subsequently refaxed to the prosecutor on September 16th. And it appeared in the Los Angeles Times, I believe the 14th or 15th, before it had actually been delivered. Mr. Goldberg's first point seems to be that all of these questions and issues have already been argued and rejected. And of course, Your Honor is the best judge of what you have previously rejected. We believe that the prior ruling was based on a very narrow premise addressing the admissibility of false information being leaked. And what we're talking about here is just the accurate information. And we're not going to try to evade Your Honor's prior ruling by offering evidence of false information being leaked and argue from that we can imply there was some connection with the actual planting of evidence on the sock. We realize Your Honor's ruling has foreclosed that. But what we're talking about here is a different inference drawn from a different fact, inferring from the fact that accurate information was leaked to the news media before it was delivered to the prosecution or the defense, that in and of itself gives rise to some distrust of the attempt by the Los Angeles Police Department witnesses to create the impression with this jury that the evidence was very carefully handled, that the information was kept in very secure form, and therefore that they need not be concerned about any risks of compromising this evidence. And quite simply, that is a faith, that is a trust they should not have in the evidence based on the performance of the Los Angeles Police Department in this context, in the context of leaking information. Mr. Goldberg makes the point that the standard of materiality is actually more liberal with respect to discovery than it is to actually offering the evidence. But what he overlooks is that here we have the evidence. What we are seeking to offer is actual publication of information and to show when that information was published as opposed to what kind of control existed over the information at the time it was published. There's no hearsay problem because we're not offering this to prove the truth of what is asserted. We are simply offering it to prove when it was leaked, when it was released. And authenticating that will be a very simple matter. In fact, we already in the 402 hearing heard the testimony of Michelle Kessler that very carefully defined who had access to this information at the time it was leaked. Now, Mr. Goldberg says, well, we can't show that someone close to the investigation was responsible for the leaking. It is a logical inference. If the testimony is that information was tightly controlled, that the number of people who had access to that information can be counted up and accounted for, that if the information is then published, the only explanation can be that those people who were responsible for its integrity and for its security were either corrupt, incompetent, careless, or manipulative. And that's precisely the question that we're raising about the handling of the evidence in this case. And finally, Mr. Goldberg did not address at all the question of the relevance of this evidence as rebuttal evidence to the testimony of the detectives, of the lab technicians who described a procedure in order to enlist the trust of the jury set up to maintain the security of this evidence.
Thank you, counsel. All right, the issue before the court is the relevance of the proffer just made by the defense regarding leaks of information, most of which turned out to be accurate information, some of which was decidedly inaccurate. The issue being whether or not premature disclosure to the news media before it's known to the prosecuting attorneys or before it's known to the defense or the court is probative of some of the issues that have been raised in this trial. The defense is quite correct that they have vigorously raised before the triers of fact challenges to the competence of the individuals who collected the evidence, have raised issues regarding carelessness in its handling, and those issues are before the court both through the cross-examination of the prosecution's witnesses and the testimony of the defense witnesses that have been offered to date. The problem that I have with the offer is that the probative value of news information, the probative value given what it attempts to prove is very slight, to the point of being irrelevant. And under Evidence Code Section 350, I will exercise my discretion and make a finding that it is not relevant. Also, I viewed this in light of Evidence Code Section 352 as well, in that given its slight, if any, probative value, the time that would be required first to present it and then to allow the prosecution to rebut it by bringing in timely news information would be an undue use of the court's time. I'm reminded of the Callahan cartoon that's often published regarding what the legal process appears to have become. And this is not a trial by news media sources, leaks, tabloids, or otherwise. The objection will be sustained on both grounds.
Same with respect to Mr. Bosco, Your Honor.
I have no idea what other relevant information they may have. As to these two issues, the answer is yes, I'm making a finding that they have no relevant information to offer. I have no idea.
Before you see the jury, just, Your Honor, let me just respond as far as Mr. Bosco ruled this.
All right, how about Ms. Savage? Ms. Sager, I understand your client is out of town, not due back until the 21st.
But if there's going to be another opportunity or request to bring her to the stand, I'd like to be heard and have an offer of proof made as to what possible relevant evidence she can offer, given that the court has now ruled that any evidence with respect to inaccurate portions of her report cannot be offered, and that any accurate portions of her report cannot be offered. I fail to see what's left that Ms. Savage can testify about. She's not the custodian of records, so if the tapes are or are not going to be introduced...
Well, counsel, let's not argue the issue now. She's out of town. Counsel have declined to release her from the subpoena. We'll take it up on the 21st if they insist on calling her to the stand. All right, it's premature. Thank you, counsel.
Your Honor, in light of the rulings you just made, I need a little bit of guidance because the very next witness, as you know, is Michelle Kessler. And it's my understanding from the court's rulings that obviously testimony even regarding reliable and accurate leaks cannot be disclosed to this jury through either Bosco or Savage. My question has to do with Michelle Kessler. And in terms of timing, I can talk about this now if you'd like, or we could take a short recess after we finish this witness so I can make the applications at that time if you'd like.
Let's finish Dr. Reeder's first,
Okay.
and then we'll see where we are in terms of Kessler. We also have counsel here in the courtroom who represent Mark Furman, who wanted to address the court on certain issues.
Okay.
All right, counsel.
Morning, Your Honor. My
Right.
name is Lori Butler. I'm Robert Turtelow's partner.
Good afternoon, counsel.
And we are here basically as a result of finally having obtained a copy of the protective order that was issued with respect to the Laura Hart McKinney tapes. And specifically, I would reference the court to two things. My partner sent you a letter referencing his concerns about the confidentiality with which the tapes are going to be maintained and the right of counsel for the defense to make commentary about such tapes on such shows as Larry King Live and other television and radio programs. Those concerns were expressed by Mr. Turtelow. We are also here, Your Honor, this afternoon to seek access to the tapes on behalf of Mr. Furman. The reason we are seeking such access is that, first of all, the order was made in our absence without our knowledge and without any opportunity on behalf of Detective Furman to object to or make any statement with respect to his interests. And we believe he does have an interest in these tapes. They are his voice in great part. And again, I am speaking without having heard the tapes because we have not had access to the tapes. But it is my understanding that they represent a dialogue between Ms. McKinney and Detective Furman, which was to form the basis for a Hollywood screenplay. With that in mind, I think the attorney for Laura Hart McKinney has noted in an LA Times article which appeared on August 12, 1995, that there was some sort of business relationship between Detective Furman and Ms. McKinney. And from that, I think it's implicit that Detective Furman has rights to those tapes. And
I'm sorry. Are you arguing that because it's reported in the LA Times that I should
No.
take that as
No, I'm not, Your Honor.
evidence of a business relationship?
No, I'm simply pointing to that as a statement by the attorney, by the purported owner, the woman who has claimed before this court and other courts that she is the owner of the tapes. We are taking the position, and we are representing to this court, that to the extent that the Detective Furman's voice is on that tape, and he is an author of the statements in that tape was to be used ultimately for a screenplay. It is categorized in the protective order as intellectual property, which connotes a creative sort of written or transcripted creation, that Detective Furman has some rights to these tapes and certainly has a right to access to them along the same lines as has been given to the defense counsel, the district attorney, and the court, and their respective support personnel.
All right, Ms. Butler, let me ask you this. Did your client, Mr. Furman, have a contractual consulting agreement with Ms. McKinney, which includes access to the materials, copies, transcripts, et cetera?
It is my understanding that the relationship was one where he was to be involved in the ultimate exploitation of these tapes on some basis. I do not know the exact nature of the contractual terms because this was a relationship that evolved and the taped sessions occurred over several years. and the tapes were never ultimately reduced to a screenplay or a published work, but he clearly has rights in those tapes, and it would seem to me, Your Honor, that he would have a right to at least hear what is being said. And let me just focus on the second concern, and that was what my partner expressed, which is, and as I read the order, it does not bar anyone from voicing publicly their reaction to the tapes, whether they found them to be upsetting, to be chilling, to be anything. Once that happens, you have a body of tapes which have been characterized by one party with no prohibition by the court. And there could be further injury and defamation to Mr. Furman, Detective Furman, and he has no ability whatsoever to rebut any of this because he's been denied any access to his own voice.
Ms. Butler, has your client made any requests of Ms. McKinney for a copy of the tapes or the transcript?
He is making it through us at this time, Your Honor.
Well, the person who actually has the possession and control of the tapes and the transcript is still Ms. McKinney. What has been transmitted to the court is a copy. Have you made any inquiry of Mr. Schwartz or Mr. Regwan regarding Ms. McKinney's?
I'm going to defer to Mr. Town because he has made those attempts and he is our co-counsel at this point, and I'll let him address that because he had made that inquiry.
All right. Good afternoon, Mr. Town. Would you spell your names for the court, please?
T-O-W-N-E.
Thank you.
Richard Town for Detective Furman. On Friday, I attempted to contact Mr. Schwartz at his office. I left a very detailed message advising him of our interest, our representation, and our concern. Because we understand, without having had the same access that other parties involved in this matter have had to the tapes, that they are protected and protectable, and that Detective Furman has a right, an interest in those tapes under perhaps copyright law, under perhaps California's common law with respect to the protection of ideas disclosed in a confidential relationship. And the upshot, I have not received, at least as of the last time I checked my office today, any response from Mr. Schwartz. Having been provided a copy of your order, we can see, I think there is great significance to the fact that Mr. Schwartz characterized the tapes and the other material as intellectual properties, suggesting, properly so I believe, that they are creative works, works of fiction, created for dramatic purposes for subsequent exploitation in a commercial context. We have now a situation where, pursuant to the court's order, one, if not the creator of this potentially valuable, and we say potentially valuable because Mr. Schwartz has so characterized the material in excerpts and articles from the Times, we have those potentially valuable properties outside of Detective Furman's access, custody, control, or review, where their authenticity and in fact the manner in which they've been maintained in custody over some years has not been determined. And I think it ought to be determined. So our situations, we would like equal access to that which the parties, pursuant to the court's order, now have.
All right. Have you consulted with counsel for either side, either the prosecution or the defense, and asked for their cooperation in contacting Ms. McKinney for this purpose?
No, we have not had the chance to do so, but would like to do so.
All right. Do people have any position?
Sounds to me like they're asking for Detective Furman's right to know what's on the tapes and the transcripts, and as long as the proprietary interests are preserved as indicated in the court order, the protected order, people really have no position.
Mr. Cochran?
As regards Mr. Simpson, the problem is, and I don't have to give this court the history of what happened to these tapes. We're the ones who went and got these tapes. What the court has is a copy, which I arranged to have brought out here, or what the court will have shortly. What counsel has is a copy. These are impeachment. They don't have a right to these tapes. Furman doesn't have a right to these tapes. What they should be doing is talking to Matthew Schwartz and Ron Regwan regarding these tapes. I'm glad they admit it's Mr. Furman's voice, and it is his voice. This is not a screenplay. It's a dialogue, and it's an interview is what it is. It's called an interview with Mark Furman. Now, we have no desire, and will not, short of an order from this court, turn anything over to them, because this is our impeachment of a witness who's still on the stand in cross-examination in a criminal case. And that's the issue in this case. And the court knows beyond that where this case is going to be, where we expect this case to go beyond this. So we're not going to cooperate with them with regard to this. They can talk to their client if they want to know what he says. He can tell them what he said over the last 10 years. We feel very strongly about this. This is the fruits of Mr. Simpson's lawyer's labors. And we are now going to use those, as the court knows, for impeachment of this witness and beyond this trial. So we feel very strongly about it.
May I respond?
Yes, Ms. Butler, the problem I have here is that under the discovery laws here that govern the conduct of this case, the defense has no obligation to disclose information that they are going to use for the purposes of impeachment, which they claim these tapes are. So I don't feel that I'm in a position to order them to turn this over to you. However, it seems to me that what you have is at this point in time, a civil dispute with Ms. McKinney regarding whose property these really are. And I would assume that she would be cooperative with Mr. Furman and his counsel in turning over a copy of the tape and of the transcript, because she cooperated with defense counsel. When the prosecution counsel made contact with her, she was also cooperative with them immediately upon learning that they wanted to have a copy, and in fairness, gave them a copy and subjected them to the protective order. I assume that because of the relationship between Mr. Furman and Ms. McKinney over a number of years, she would, at least out of a sense of fairness or obligation, provide him with the equal access, a copy, and the transcript. But do you understand the dilemma that I'm under, that I'm here in a criminal trial?
No, I certainly understand. My concern was, it seems to me that the protective order really at this point precludes us from getting access to the tapes by virtue of the wording limiting the parties that may have access to it solely to those defined in the protective order.
Well, I don't...
And I don't know whether Ms. McKinney or her attorney has the right to unilaterally, at this point in time, disseminate tapes to Detective Furman or his counsel, barring a further order of this court, which is why we're here. If we felt we could accomplish this solely through a dialogue, a request, an agreement with her or her attorney, we would have done that. And we did try to do that, but we got no response. But we feel, having learned about the order and having first seen it today, that
Counsel,
that's what
let me do this. Let me have my clerk call Mr. Schwartz's, Mr. Regwan's office.
Okay.
I'll ask him if they're willing to cooperate with you, if we clearly modify the protective order to allow Detective Furman and his counsel one copy with an order against any additional duplication, and see if they have any objection to providing that to you within 24 hours.
All right.
All right, so why don't you stand by? I'd like to finish my jury trial this afternoon, so I'll have Mrs. Robertson or my law clerk, Mr. Byrne, make the contact with Mr. Schwartz and Mr. Regwan. We'll see if we can accomplish it the easy way.
Okay, thank you, Your Honor.
Thank you very much.
Don't go away.
We'll be back here.
All right, Mr. Ming, would you make sure that Mr. Byrne takes care of that? Thank you.
Your Honor, can I just inquire with respect to Ms. Kessler when it is we are going to meet her, if at all, this afternoon? We did agree to the defense, apparently, that we have her here when they needed her. So I just wanted to...
Well, we still have a 402 issue before she testifies. We must conclude Ms. Clark's cross-examination, Mr. Blazer's redirect, Ms. Clark's recross. So, and it is now 2:30, and this is a 5 o'clock day, so my guess is we would get to her 4 o'clock, but that would be starting the 402 hearing. So, my understanding is that she's at Piper Tech, correct?
Right.
Which is 10-15 minutes away. So why don't you leave her on call?
Thank you.
All right. Is that agreeable to you, Mr. Neufeld?
That's fine, Your Honor.
Okay, but she is available.
I spoke to her about an hour ago. She was.
Okay. With reporter? All right, let the record reflect we've been rejoined by all the members of our jury panel, that Dr. Frederick Reeders is on the witness stand undergoing cross-examination by Ms. Clark, and Ms. Clark, you may continue.
Thank you, Your Honor. Good afternoon, ladies and gentlemen. Sir, I've conferred with your counsel, and he tells me that you have billed so far $13,000 for your services.
Yes.
Does that sound right to you?
Correct.
That does not include your time in court today, is that correct?
Correct.
What else does that not include?
Anything since June 16th.
And there were hours spent after June 16th, I take it.
Yes.
Do you know how many hours were spent after June 16th, 1995?
No.
Can you estimate for us?
Honestly, I can't.
Whatever the number of hours they would be, it was your testimony, I think, earlier that you bill at the rate of $250 an hour, correct?
For actual work that pertains to the case, not just time spent, but actual work pertaining to the case. Some of the work is I'm learning things. I don't bill for that.
All right. In this case, sir, did you spend actual time working on the case since June 16th, 1995?
I can't tell you.
You can't tell us.
I don't know.
At some point, you will submit a bill for those hours, will you not?
Yes, I hope to after I return this time.
And we cannot obtain that information right now.
Overruled.
I know it'll be over $10,000, but I don't know whether it'll be 12, 20, or 30. I really don't. I know it'll be over $10,000 because I can just see in my head that I've spent more than 50 hours right here in Los Angeles.
All right. Then that would be another over 10,000 in addition to the 13,000 you've already billed, correct?
Yes.
Now, sir, if you will recall on July 24th, when I pointed out to you that the gate and the sock gave very similar readings to Agent Martz's own unpreserved blood, your answer was yes, surprisingly yes. Do you recall that?
Yes.
And when I asked you how you could account for that, you stated that you could not account for that, and you called the results of Agent Martz's unpreserved blood absurd. Do you recall that testimony?
Approximately, yes.
Would it help you to determine whether or not that is exactly what you said if I showed you a transcript of that testimony?
If that's what it says, I'll concede to it if you have it right there. I don't want to spend any more time on it.
Would you like to look at it, sir?
No, not particularly.
Now, when you called the result on Agent Martz's blood absurd, it was your testimony that you felt it was absurd to find that amount of EDTA in normal blood, correct?
That's my opinion, yes.
Now, after you wrote your report on July 17th, sir, the chromatographs depicting the readings on the gate and the sock stains did not change, did they?
I don't know what.
The graphs that were generated by the testing performed by Agent Martz on the gate and the sock stains were the graphs that you examined from March until you wrote your report on July 17th, correct?
Yes.
Those graphs did not change after July 17th, did they?
I didn't see any change, no.
And yet, in that report on July 17th, as you previously testified, you wrote that your interpretation of those graphs revealed the presence of one parent and one daughter ion on the sock stain and on the gate stain, correct?
Yes.
And then, after you wrote the report on July 17th, and the graphs did not change, you did get the results of Agent Martz's blood that gave the same one parent and one daughter ion result, correct?
Yes.
And then you testified on July 24th that you found then that the sock chromatograph showed the full daughter spectrum, which had not been contained in your July 17th report, correct?
Yes.
Now, given the result, isn't it true, sir, that given the result on Agent Martz's blood, you realized that you could not maintain that the substance detected on the gate and the sock stains came from preserved blood unless you changed your opinion as to what the graphs showed on the evidence stains. Isn't that true?
No.
You did change your opinion, however, with respect to what was shown on the graph for the sock stain. Isn't that true?
No.
But your report said did not document a full daughter spectrum, did it?
It said nothing about the full daughter spectrum.
In fact, it affirmatively said one parent and one daughter. Isn't that true?
That's the only things it referred to, yes.
And in your testimony, you felt it was important to point out to this jury that your interpretation of the sock graph showed the full daughter spectrum on July 24th. Isn't that true?
At that point, yes, after a conference with Dr. Martz.
And Dr. Martz, you mean Agent Martz? Agent Martz?
Agent Martz, right, I'm sorry.
And did you see Agent Martz testify on television, or did you read his testimony in transcript form?
Both.
And you also, of course, heard his opinion that the substance that was detected in the gate and the sock stain and in his blood may be consistent with the EDTA, but could not be so identified, correct?
That's what he said, yes.
And he said that because he felt that it would be inappropriate we're all doing it.
We're getting it.
He said that because he felt it would be inappropriate to say that the EDTA substance was identified unless the full daughter spectrum was present. Isn't that true?
Pretty much, yes.
Now, sir, when you indicated previously that you could not account for the results shown in Agent Martz's own unpreserved blood, after you received those results on Agent Martz's blood, what effort did you make to perform any tests on, say, your own blood to see if it came out with the same results as Agent Martz?
I didn't make any such effort. It wasn't in a contest of whose blood is better or anything. That's not, I didn't do any experiments. You know that.
Sorry?
I've told you before, I didn't do any experiments at all.
The answer is then none. You
That's
did
what
no
I-
experiments.
Again, yes, I didn't perform any experiments.
And you've indicated to counsel on direct that there was a method by which you could quantify the amount of blood in a sample in order to be very precise about the amount that there is in there, correct?
It's very easy to quantify the blood, yes.
Now, you actually had blood stains 47, 50, and 78 from this case.
Objection. I'd like to approach.
All right, with court reporter, please. Thank you, counsel. Proceed. Mr. Blazier.
Ladies and gentlemen, good afternoon. Dr. Ritos, good afternoon.
Good afternoon.
How are you feeling today, doctor?
I'm afraid I'm terribly irritable. This bronchitis and all has made me quite irritable. I'm sorry if I got carried away by it.
Has Ms. Clark's questions made you feel any better?
Make fun?
Has Ms. Clark's questions made you feel any better?
After lunch, I felt better.
Sustained.
Dr. Ritos, I want to just ask you a few questions about the sconce matter. Were you the only forensic toxicologist to find oleander in that tissue?
No,
Were you even the first one?
no.
Who was the first one?
Dr. Randy Baselt of the Institute of Chemical Toxicology outside of San Francisco.
And is he a very highly respected forensic toxicologist?
Yes.
Now, Dr. Henyon, is he a highly respected forensic toxicologist?
He's really not a forensic toxicologist. He hates to go to court, so...
Now, in stating the opinions that you've stated here today about the sconce matter, have you relied on Dr. Henyon's report in the sconce matter?
Did I rely on it? No, not at all.
In terms of the opinions that you stated today about what he did versus what you did?
Well, I relied on what he wrote in his report.
What aspect of his report did you rely on?
The entire report, I relied on the list of specimens that he has in it that he sent to California or Ventura. I relied on his own statement in there that what he did didn't in any way, shape, or form have a bearing on what was in there when this man died years earlier.
And are you referring to a specific part of his report that you relied on?
Well, you mean... the
Specific
yes,
sentence?
yes.
Could you read that, please?
Sure, be glad to.
What page are you referring to, Mr. Blazier?
I think it's page
Sir,
one of the
this is
report.
the first page after the cover.
All right.
It is in the introduction, if you don't have a copy. I can read the whole thing, but really this is the relevant portion, right? Well, let me read the whole paragraph.
Objection, Your Honor. I think that the witness should be able to read your... I'd like to see that.
Oh, I'm sorry. I thought you had a copy.
Objection, irrelevant.
Oh,
Can I show the court?
the objections is relevance. That objection's overruled.
Could you please read that paragraph that you relied on?
I'd ask the witness read it to himself and indicate. It was to refresh his recollection, Your Honor, wasn't it?
No, he was asked what he relied upon.
Objection, hearsay.
Sustained.
Anything that Dr. Henyon concluded caused you to change your opinion in any way?
No, not at all.
Incidentally, after you finished working on the sconce matter, did the Los Angeles District Attorney's Office hire you to work on another case?
I was already working on one, and I worked on another one afterwards, yes.
And what case was that?
Dr. Boggs.
Now, I want to ask you a couple of questions about the differences between what Agent Martz has testified to and what you have testified to with respect to whether or not this is EDTA that's on the gate and the sock. Do you have that in mind?
Yes.
Is it accurate that both of you agree that the retention time that he got is consistent with EDTA?
Yes.
That the presence of the parent ion, the 293 parent ion that he found, is consistent with the presence of EDTA?
Yes.
The presence of the 160 daughter ion that he found do you agree is consistent with the presence of EDTA?
Yes.
And he agreed with that, did he not?
Yes.
Would you agree that the only difference between your opinion and his opinion is based on his inability to find the other piece, the other daughter ion, the 132 daughter ion?
Sustained. Rephrase the question.
So your understanding, what's your understanding with respect to Agent Martz's unwillingness to declare that what he saw was EDTA?
That he performed one analysis where he scanned widely between 130 and 293 across the spectrum for both daughter ions, and he claimed that in that he didn't see anything. Didn't see the 132 daughter ion, that there was nothing there because the computer didn't print out any numbers.
Now, this machinery that he has, the machinery that he has, you recall that we were talking before about the analogy of a television camera that's set up to focus on you and maybe scan back and forth, but not deviate very much from where you're sitting. Remember that analogy?
Yes.
And that's the analogy that relates to looking for the 160 daughter ion, correct?
Looking either at the 160 daughter ion or scanning across and seeing where it appears in that scan.
And when Agent Martz did that scan of the 160 ion, the small range 158 to 162, he found the 160 daughter ion, didn't he?
Yes.
Now, does that machinery that he has, that the FBI has at their lab, is it capable of also looking at the 132 ion?
Yes.
Is it capable of scanning that area within a small range?
Yes.
Did he ever do that?
He said he did not.
Now, did you hear Ms. Clark's questions about whether it's incumbent upon a scientist to do every possible test available to test a hypothesis?
I remember the question, yes.
Did Agent Martz do every possible test available to try and see whether or not the 132 ion was there?
No.
Now, you indicated that Agent Martz did one test that provided some information about whether or not EDTA on a metal can might be lost by virtue of it being on a metal surface. Remember that?
Yes.
What were you talking about? What were you talking about when you referred to that?
He put some EDTA blood on a metal can surface and also on a control swatch. Then he wiped the surface subsequently, so he had a swatch from the surface and he had a control swatch, and he analyzed both.
Sustained. Rephrase the question.
Did you review Agent Martz's testimony?
Yes.
Did you read it
I
and look
think
at
he's
it on
having
video,
fun.
too? Did you hear his discussion about his test results with respect to the amount of EDTA he got off of his metal can versus the cloth swatch?
Yes.
And what's your understanding of that testimony?
That he found EDTA in both. There was less in the one from the can than on the control swatch.
And scientifically, what inference can be drawn from that?
Well, one obvious inference is that he got less back than what he put on the can, so some of it was broken down by the can, swallowed by the can, or otherwise. But the likely thing is destroyed, broken down. Altered.
Would it be fair to characterize Agent Martz's testimony with respect to quantity, that his opinion is that he didn't find enough of whatever it was that he found, that it could have come from a purple top tube? That he didn't find as much as he would have expected to find?
In my direct, I already answered that. He had no clue as to how much he started with in his samples. So how could he determine what the concentration was? He could only apply amounts. If you don't know what the concentration is, you don't know what you're dealing with. So there was EDTA in the blood, and if it was a tiny, tiny amount and the concentration was the same in an EDTA tube, he doesn't know what the concentration was.
Did he do any experimentation or anything as a result of you watching his testimony indicating that he tested to find out how much EDTA he would expect to find after 8 months under the conditions of which these samples were subjected to?
No.
Is that something that if you were trying to do every possible test to test a hypothesis that he should have done?
Yes, I would think so. At least partly. I mean, for a period of time, not necessarily 8 months.
Now, if Agent Martz were testing the hypothesis as to whether food or other substances can create levels of EDTA in the blood equivalent to the amount found on the gate and the sock, what would be the proper way to test that hypothesis? What would one proper way be?
To test 10 or 20 random blood samples from normal people, or as many as you can conveniently. It's a simple test, so you can test a lot. It's a standard procedure.
Do you feel that him testing his own blood after placing it in a red top tube for a period of time is an adequate test to determine how much EDTA he might have had in his blood originally?
Not without adequate quality control, such as testing red top tubes, if you put things in them, whether there's any EDTA in the stopper or in the lining, in the silicone lining, which wouldn't be too unusual. You know, without that, it's not a very good way of getting an answer. Besides that, if you put blood in a red top tube, you can't test blood, you test serum or plasma.
Why is that?
Because it clots.
How long does it take to clot?
5 to 7 minutes.
Have a minute, Turner. Dr. Reeders, do you know of any other compound that would give you the retention time, the 293 and the 160 ions, as EDTA does?
I don't know of any, and I have not found of any. I've specifically searched not the Merck index, as was mentioned, but there's a separate Merck index publication which lists molecular weights. And by looking at those substances that have a molecular weight of 292, and then looking at their structure, I mean, you know, there wasn't anything in there that indicated that I could get a 160 or a 132 ion out of those in a mass spectrometer. I also looked in an index of mass spectra that I have and didn't find anything in there that matches this particular pattern.
Now, you can't say, since you haven't looked at all 11 million or how many ever organic compounds there are, you can't say whether there might not be some other compound out there that hasn't been looked at that might look like this, correct?
That's correct. That's always true. I've said that before. You can only work with what you know.
And that's true with any kind of substance that you're looking for, that you're examining with mass spectrometry, correct?
And any
Sustain. Sustain.
Is that true with respect to any compound that you look for with mass spectrometry?
yeah, and any test, any
Now-
form of mass spectrometry. You can't give an absolute answer. You cannot identify something to the exclusion of all other compounds unless you do it purely by faith alone.
Now, we've been talking about tandem MS, or MS-MS in this case. Why is it, why do you repeat MS and then repeat it again? What does that mean?
Well, the technique is a little bit different. I think I explained what MS is. I think maybe Roger March did too, about weighing a molecule, breaking it up like a diamond, and then weighing the pieces. In MS, what you do is you put the material into a mass spectrometer. It weighs it, and then it takes preferably the whole molecule, or the whole molecule with a charge on it, a hydrogen ion charge, and filters it into another mass spectrometer alone, all by its lonesome, without all the other junk that's sitting back there. So you've isolated that particular ion. Then that second mass spectrometer cuts that into what's called daughter ions, into 2 pieces, perhaps 3 pieces. It's called by colliding with gas molecules. That's how it's done, gently. And then it weighs those pieces. So that is the second mass spectrometer. The better way is to take it into the second mass spectrometer, then break it up, and then again filter out one of the ions into a third mass spectrometer for measurement. That's what you have when you have MS. You can continue that virtually ad infinitum, not with his instrument, but with some instrument. So you can go to the 5th mass spectrometer.
Is it accurate to describe then that the first MS is looking for the parent ion, the 293, and the second MS looks at the daughter ions?
The first MS looks at the parent ion. The second MS takes that parent ion purely and breaks it up. And the third MS measures it.
Now, are tests done to determine identification of substances using just MS?
Of course, they've been done for a long time. As a matter of fact, that is a widespread standard.
And did we
this
have,
technique is a relatively recent one.
when MS was designed, did we also have MS-MS, or did that come along later?
Afterwards, not terribly long in research form, but it came afterwards.
Is it accurate to say that testing is done all the time where identifications of substances are made based on just MS?
Yes.
Doctor, after being cross-examined and hearing Agent March's testimony, do you stand by your opinion that what was found on the back gate and the sock to a reasonable degree of scientific certainty was EDTA?
Yes.
Do you stand by your opinion that the probable source
for that EDTA was a purple top tube?
Well, probably yes.
Do you know of any other possible source for that amount of EDTA?
Yes, theoretically.
Any other source that you would expect to find in someone's human blood?
If they have been treated with intravenous calcium EDTA within the last 8 hours for lead poisoning, yes.
Other than that?
Or for other forms of treatment, diagnostic or treatment with disodium calcium EDTA.
How about just after normal diet?
No way.
That's all I have.
Ms. Clark?
You mean the readings that Agent Martz obtained in his unpreserved blood, there is no way that those could result from him having a normal diet in which he ingested food that contained the preservative EDTA?
In my opinion, that's correct. It's no way.
So the result that he got is not there. It's unreal. Is that right?
No,
Overruled.
no, I didn't say the result that he got isn't there. It's there on paper. How it got there is the question of what's its source.
What are you trying to infer, Dr. Reeders? Are you trying to tell us that you think he added EDTA to his own blood?
I didn't say that, you did. I said, well, I don't know what the source is. It could be contamination, it could be a mix-up. I seriously doubt that he would add it to it. He's an honest man. He's not a crook. But there are any number of ways that this can happen.
And then one way that you've just mentioned was through the possible presence of EDTA in a red top tube. Is that one way you just mentioned?
That's a possibility. He never checked it out, so it's not ruled out. So that's a possibility.
Well, Dr. Reeders, did you ever check it out? Did you ever run any tests on a red top tube to determine whether there were trace amounts of EDTA contained in it?
Sustained.
On a red top tube?
Yes, if you did any experiments whatsoever, and the answer was no.
Doctor, you talked a little bit about concentration with counsel. If EDTA is assumed to be present in the evidence and in the reference to blood, and you wanted to prove that the blood on the gate and the sock came from preserved blood, as a scientist, wouldn't it be logical to conclude that the concentration should be the same in the evidence and in the reference blood?
If they are both fresh, yes. If one has been sitting on a fence for various periods of time, it wouldn't have to be the same. What I was mainly saying is that you have no clue as to what the concentration is because you never measured how much blood you have.
All right. But then you could, as a scientist, test that hypothesis by
There's a
doing
plow in
tests
front of
to
my house
quantify
right now.
precisely the amount of blood. So you could determine exactly whether the concentration was the same, could you not?
Overruled.
Yes, I said that's what you can do. In my direct, I even said how to do it.
Now, Dr. Reeders, if you, as a scientist, wanted to affirmatively prove the presence of EDTA in evidence stains, you could conduct exactly that form of testing, could you not?
Well, I could conduct it, but I wanted to prove exactly or approximately. Of course one can do those tests. That's why I proposed them. They're not tests that can't be done.
And did you propose that such testing be done on the evidence, in this case, to counsel, defense counsel?
Sustained.
All right, Dr. Reeders, you indicated that you relied on Dr. Henyon's report with respect to what tissues he tested. Is that correct?
I'm sorry, where are we now?
We're in Wisconsin.
Oh.
You
Yeah,
indicate...
I relied on his report as to what tissues he tested, sure, because that's what he reported as having received and tested. I also relied on Dr. Lovell's letter stating what tissues he sent.
All right. And then it's your position that based on your review of that report, that he never tested the tissues taken from the 1985 autopsy. Is that correct?
Yes, that's correct. He says so himself.
Would you change your opinion, Dr. Reeders, if I were to show you a videotape of autopsy tissues being delivered to the defense toxicologist, Brian Finkel?
No. What's
Objection.
that got
Your
to do
Honor,
with it?
May we approach?
Nope. He said no, wouldn't change his opinion. Proceed.
In other words, if you were to be...
No. Sidebar with the court reporter. That appears to be from the 91 exhumation, correct?
Yes, that indicates that some of the tissues delivered, and there's no dispute that exhumation tissues were in fact delivered to Dr. Henning.
All right.
They're not.
In the report. Someone's in the report.
I gotta rewind it. I went too far just
In the
by a
report, is there
tiny
reference to
bit,
any
so I got
samples
to.
from the original
Because
autopsy?
they might have dismissed this guy. I don't know. Hold on, I gotta go back even further. We're gonna watch it from here. if they don't dismiss this guy right here, we might have him again tomorrow. I cannot tell. From the thumb, it looks like we might have him again tomorrow. But we got through a ton today. I don't know why.
Gentlemen, would you just step back real quick into the jury room? I need to take a look at something. Well, before we do that, the report of Dr. Henyon that you've given to me and directed my attention to page 5, samples 001 to 007, that appears to be from the 91 exhumation, correct?
Yes, that indicates that some of the tissues delivered, and there's no dispute that exhumation tissues were in fact delivered to Dr. Henyon.
All right.
Those are the only samples
They're not.
in the report. So one's in the report.
All right, in the report, is there reference to any samples from the original autopsy?
In whose report? In Dr. Henyon's report?
Yes. I mean, what is the basis for you asking these questions?
Because on redirect, the witness was asked.
No. I'm asking within the reports that you have, where's the contradiction?
No, that wasn't the point, Your Honor. Counsel asked Dr. Reeders whether, I think the witness ought to be excluded for this. I really do. Counsel asked Dr. Reeders whether reading the report refreshed his recollection as to whether Dr. Henyon got 85 autopsy samples or not. He indicated yes. He indicated that looking at the report, he was able to confirm the fact that Dr. Henyon never got 85 autopsy samples, and that's what I asked him.
All right.
I went back over that. I said, how does this report indicate to you that he did not get the 85 autopsy samples?
And that's what you propose to ask at this point?
No, I already got, I let that.
Or do you ask him what tissues were tested?
Here's my question. Then it's your position that based on your review of that report, that he never tested the tissue taken from 1985 autopsy. Is that correct? Answer, yes, that's correct. He said so himself. Then I asked, did you change your opinion? So it is Dr. Reeder's testimony that the review of this report confirms his opinion that Dr. Henyon never got 85 autopsy samples.
He wasn't there when this was done. He has Dr. Henyon's report. Dr. Henyon's report said, I got this stuff in 1991. Dr. Lovell's report says, I was there when we got it from the mausoleum. It looked like mud. This is completely improper. I tried to raise this initially. I think the whole line of questioning is improper. I asked that the jury be admonished to disregard everything about sconce as being completely irrelevant and done in bad faith. There's nothing in this report indicating that he tested anything other than what Dr. Reeder said he tested. What Dr. Reeder said is based on Henyon's report. That's all he has.
You know, my God, this is reality standing on its head. It's absolutely clear. If you look at the videotape, Your Honor, we have all the memos from Brian Finkel. We have all the letters that indicate that he absolutely did get and test 85 autopsy tissues. There's no question about this. I don't think perhaps counsel doesn't know.
He Henyon or he Finkel?
He Finkel and he Henyon, both. Finkel hand-delivered samples to Dr. Henyon, and some of the samples that he hand-delivered were, in fact, 85 autopsy tissues that were given to him.
Right, where do we have that documented?
Well, where do you get that? You're talking about in this report?
Anywhere.
I'm not the one who asserted that this report was competent.
I saw that, Kelly. That was awesome.
That's what counsel used. I contend otherwise, and that's why I wanted to show him the videotape, because there was no way from this report that he could possibly have reaffirmed his position that there were no autopsy tissues given to him, because the manner in which it's documented here is insufficient for him to say one way or another, and yet he has. He has said that based on this report, he can say he never got autopsy tissues from 1985. That he can't do that, and he's formed an opinion based on something he cannot, that doesn't give him the information he claims it does. I have something that will give him that information, and I want to confront the witness with it. And I think that on cross-examination, it's certainly fair game to do
All right.
so.
You're saying that he's used something to refresh his recollection that you say is an insufficient basis for him to have refreshed his recollection. Therefore, you're entitled to cross-examine on some videotape. Is that what you're saying?
No, I'm challenging the basis of his opinion. I'm challenging, first of all, the opinion itself, but also the basis of it. Number one, the report can't possibly be used as a basis for him to conclude that there was no 85 autopsy tissue given. Secondly, would it change his opinion, and certainly I'm entitled to do that, Your Honor, with an expert, would it change your opinion, doctor, if you were to see this videotape?
Which does what?
Which shows the tissues being cut and split to give to Dr. Hinkle, who was working with Dr. Henyon on this case for the defense. This is a 1-minute videotape.
One, I don't think that proves anything. Let's assume it's true. Dr. Reeders wasn't there for this. It can't refresh his recollection. It's not in Dr. Henyon's report. Dr. Reeders has testified that that's what he has, is Henyon's reports, which says this is what I tested, and it's from the 91 exhumation. Nothing in there about testing anything else. It's reasonable for him to say, this is his report, this is what he tested, so he probably didn't test anything else. That's not impeachment.
Your Honor, this witness has stated in categoric terms, very definitely, that the 1985 autopsy tissues were never sent for Dr. Henyon to test. He's been very emphatic in his testimony about that, Your Honor. You know, and now we're going to backpedal a little bit and try and pretend that didn't happen. It did happen. And we have the right to challenge that opinion because it's fundamental to the discrepancy in their results. And Dr. Reeders knows that.
I would like to make a discovery request on anything they have that shows that Dr. Henyon, in a report, tested something other than the report we have. If there's another report, we should be entitled to see it. As well as anything that shows that Dr. Reeders would know something that Dr. Henyon did that's not in his report.
And, Your Honor, let me point out something in Dr. Henyon's report as well. There is a listing. You can see in the key where it talks about the tissue samples provided from Dr. Reeders via Federal Express. Right? That's on page 5.
Page 5.
At the bottom of the page it says samples 1 to 7, delivered by Federal Express from Dr. Reeders' laboratory. Okay?
Wait, at the bottom?
At the very bottom.
On page 5.
Yes. Samples from 001 to 007.
All right, my copy here says samples 001 to 007 hand-delivered by Dr. Finkel.
Different reports.
Well,
Show the
maybe
court.
that's why I'm having a problem here.
Yeah. At the bottom it shows 001 to 007 as specimens sent from Dr. Reeders' laboratory via Federal Express. If you will look at the listings above that on page 5, Your Honor, you will see that there are R008 through R0016, which indicate other samples recovered from Dr. Reeders. And I really think that the witness should be excluded for this, but...
All right, looking at page 5 of what you've just given to me, would you direct my attention where it talks about 001 to 007 being 85 autopsy samples?
I'm not saying that it does. It's actually R008 through R0016. You see, what occurred is that Dr. Henyon got a split of Dr. Reeders' tissues. He also got, however, autopsy tissues that had been maintained by the coroner at the time of the exhumation. In other words, in 85, there were tissues removed from the body. Some were kept at the coroner's office, some were given to Randy Basel, who later forwarded them to Dr. Reeders. The tissues that were maintained in a preservative at the coroner's lab, Dr. Finkel was given a split of those and by Dr. Lovell, and that's what's documented in the videotape. And he took those to Dr. Henyon. And in addition to that, some of the frozen tissue samples that Dr. Reeders had from the 85 autopsy were also forwarded to Dr. Henyon. And Dr. Finkel and Dr. Henyon have records that will verify that. I also have a letter to Dr. Henyon from Roger John Diamond, in which it indicates that the defense wishes to retest the same materials which the prosecution expert tested. And of course that makes sense, because how are they going to convince the people to dismiss a case unless they make sure that they do test the same tissues? Otherwise, the people have the very argument that Dr. Reeders is trying to proffer, which we know is untrue.
All right, Dr. Reeders, why don't you step out of the courtroom, please? Why don't you step out of the courtroom, please? Thank you. Well, we got two different reports here, that's for sure.
I mean, we need provided with copies of both. That's our only copy.
All right, let me see this video, too.
tissue from Timothy Waters from the autopsy in 1985. But the jar that the Ventura coroner kept had all of the tissue together in one jar. He's now giving it to Dr. Finkel. And these other 6 plastic jars are the jars from today's autopsy. They're not even labeled yet. They're after.
Those are the same ones that you have, that's in our label.
Actually, the first minute is sufficient because it's identified as being narrated. We can freeze frame onto the jar itself that shows the coroner's number and the date of the autopsy, 1985, so that it's clear that on that jar there are 85 autopsy tissues. We don't need that last part.
It's not proper identification. Let's assume it was, however. He's already said this is not going to refresh his memory about anything because he wasn't there. It'd be completely improper to show it in front of the jury to this witness who's already said his memory's not going to be refreshed. We want to bring him in, let him watch this, and then you can ask him again, but he's already said it's not going to refresh his memory. I still want to see Dr. Hinyon's report of testing on those tissue samples. I've never seen it. I don't think it's in the, it's certainly not in the one that I had. I don't think it's in hers.
It is in mine, Your Honor. There's the question
All
is
right,
that
we'll take a recess. You can show Dr. Readers the tape. Show counsel where Dr. Henyon mentions testing the 85 autopsy.
Your Honor, he doesn't say it's 85 autopsy tissues. He does it by number.
I understand that. I understand that.
And I'm not asking to refresh his memory. I'm asking to show him something before the jury to see whether or not it will change his opinion any. And I cannot believe.
Well, I got to tell you, this is an incredible amount of sidetracking on a collateral issue on a non-case. All right, we'll take 15. Simpson matter, all parties are again present. Ms. Clark, Mr. Blazier, have you had the opportunity to compare your reports?
Yes, Your Honor, I've determined what the source of the discrepancy is. The defense and the prosecution joined in a desire to, I thought the witness was excluded.
He is. Ms. Clark.
Yes, Your Honor. In that case, the defense
No,
and the
Miss
prosecution...
Clark. No, no, no. All right, guys. We made it. We made it to the end of another OJ. We are so much closer now. You guys are going to love it. It's so bad. So bad. But thank you so much for coming out today. I really appreciate it. I shall see you all again soon. I hope you have a great day. Bye, guys.